This is TLV1.
The Tel Aviv Review with Gilad Halpern.
Hello and welcome to the Tel Aviv Review, a program dedicated to the word, to the thought and to debate, brought to you by the Van Leer Jerusalem Institute, which promotes humanistic, democratic and liberal values in the social discourse in Israel. I'm your host Gilad Halpern, and today's interview is being recorded on the premises of the 2016 conference of the Association for Israel Studies here in Jerusalem. My guest today is a legal scholar at the University of California at Irvine and Zefat Academic College here in Israel. And he's joining me to discuss the cultural and professional orientation of Israel's Supreme Court, past and present. Professor Mohammed Wattad, hello and welcome to the Tel Aviv Review.
Hello, Gilad. Thank you for having me here.
So what would you say are the epistemological foundations of the Israeli judicial systems? Where have the judicial elites in this country gone to look for inspiration?
Well, ultimately, if I discuss the ultimate result, I think it's quite obvious to everyone who is aware of the Israeli judiciary, including the legal opinions delivered by the Supreme Court, that we're talking about a judiciary which is highly oriented and influenced by Western legal thoughts, namely the United States of America, England, France, Germany, even in Canada and other enlightened legal systems. But the thing is that this is not self-evident. Mm-hmm. Not only because Israel is located in the Middle East, but if we review the way Israel was established, legal questions through which the Supreme Court has been dealing with in the very early years of the State of Israel. And remember, until the early 60s, Israel was not a real democracy. It basically employed a military regime in all the Arab villages and cities here in Israel. Mm-hmm. So it was not quite a pure democratic classic, constitutional system.
You can say the same thing about Israel post 1967. That is
yes, but that's different.
Yes,
but that's different.
Yeah.
When I read the Kol Ha'am case of, I think it was 1951, when the Supreme Court Justice Shimon Agranat at that time says, in our constitutional system, the constitutional right to freedom of expression is a prerequisite for democracy. I salute him for that. I mean, this is courageous. Mm-hmm. This is even more courageous than all the judicial review we're talking about nowadays, because at that time you had no basic laws, you had no constitutional system, you had no democracy. Israel was involved in wars. Mm-hmm. Some of them self-existence wars. So that's what I'm talking about.
But didn't it just, you can say that about Agranat in 1951 and maybe about Supreme Court judges today. Some people have accused all of them of just paying lip service to liberal democracy.
Well, that's not correct. This is kind of, treating the judiciary like an open buffet of pick and choose. So you take one case here, another case there. But you have to have the whole picture of the Supreme Court. Mm. I don't accept every opinion delivered by the Supreme Court. And I don't agree in all of them. I have criticized some of them even stiffly, but to the purpose. Not right. Because this and that judge wrote this and that opinion, or that because the judiciary is part of the system. When I teach in the States, I meet sometimes students who are affiliated with BDS activities, and they always accuse the Supreme Court of Israel to be part of the Israel Institute. So it's part of the occupation, it's part of the violation of human rights. So my method was to give them opinions to read, and then to judge Israel, the judiciary, through these opinions. They changed their minds. Some of them never thought that this judiciary is so constitutional oriented simply because Israel doesn't have a constitution. Mm-hmm. But they didn't know that in Israel there is constitutional law. There is a basic law which is a basis for all this constitutional analysis. Mm-hmm. And, honestly, as an Israeli citizen, if there is something that I'm truly proud of, it's the judiciary. Because it can compete, unlike the soccer team, for instance, with other serious leading constitution systems in the world. Mm-hmm. Among them, the German one and the Canadian one. Of course, the American one is too much outmoded nowadays, so right. Nothing to compare.
No, but okay, so let me take you up on this about Israel being really a world-class having a world-class legal system. What were the origins of that system? Was it really part of the Zionist endeavor from the very early stages of the judicial system? Did they know that they were going to set up such a system?
Look, I don't know what happened or what happens behind the scenes, although I clerked at the Supreme Court of Israel, but still, it was for 1 year. But I know one thing, that from the very inception of the judiciary in Israel, it was very important for the judges sitting in Jerusalem to prove that they're independent. And it was a kind of question that should not be questioned from the very beginning. So we see a strong and stiff criticism against the government from the judiciary without even debating the idea of judicial review, because it sounded as self-evident. Now we know nowadays it's highly criticized by politicians who think that the Supreme Court should set aside and not intervene in every political issue or legal issue, etc., etc., etc. But for the judges, and most of them were Europeans, and that's a crucial point, because in Europe it is highly understood, especially after World War II, and Israel was established after World War II. The Supreme Court, the High Court of Justice, is sitting there to protect not only the right of the majority, but in particular the right of the minorities. That's the whole, change that happened in Europe, all over Europe after World War II.
So in Israel, it was really from the very beginning of the state because of, just this historical coincidence that it was set up after.
That's one reason, but this is one important reason, I think.
And really, who were the people? You said they were all European, so they were really coming from Europe, were they legal people, lawyers and judges in Europe who tried to impose their tradition on Israel, or just like Zionism, did they seek to set up a model that was really a bit of both?
I can't tell about Zionism simply because I have never spoken to these people to see if whether they have been trying to put some ideology, a political ideology.
No, but based on their heritage.
Yes, but based on their heritage, I think what they were most important for them is to bring their legal education from their own countries into this country. And it's unique because some of them are bringing this experience from England, others from America, and others from Europe. And these are 2, 3, or 4 even different systems.
And did they live in harmony, or were there clashes? Or
there were clashes. It's easy to see that in cases especially that deal with human rights and with cases that deal with restraining the power of the government, the extent of intervening into the government activity. However, at the end of the day, Israel has established something which is unique to Israel. And I can give you 2 examples, important examples.
Please do.
The right to dignity, and there is a recently published book by Professor Aaron Barak, Chief Justice retired of the Supreme Court of Israel, about human dignity. This right is, I think, the most developed right in the world, as was developed by the Supreme Court of Israel. There is no other jurisdiction in the world that has developed this right the way Israel did. The second one is the proportionality principle, which we deal with it when you want to balance between violating human rights for the sake of protecting, for instance, security, state security. Israel has developed this principle in a level to the extent that it can compete with Canada, for instance. I don't want to say America because America don't have it, but with Canada, with Germany. And we can see nowadays that Supreme Courts of other Western countries, they cite Israeli cases. And this is not an easy thing to comprehend.
Does it make the Israeli judiciary a more interventionist than others in the world? Because of that, being on the cutting edge?
Well, definitely it makes it more highly reputed, more respected. Judges of the Supreme Court are constantly being invited to conferences and to visit other Supreme Courts in the world to speak about their experiences, especially nowadays when we talk about the issue of security and protecting human rights and the age of terrorism. So Israel is highly experienced in this
No, but
field.
About standing up to the government, I mean, striking down government decisions and stuff like that. Does the Israeli Supreme Court engage in more battles, in inverted commas, as well?
It is viewed as, too much interventionist, as you said. But, for instance, the gas issue that recently was resolved by the Supreme Court. I was in America and I was telling them what the Supreme Court said. Seriously? Is it possible for the court to say? And, I want to take another example, not of a Western-oriented country, Egypt.
Yeah.
Yesterday, the court in Egypt decided that the agreement between Egypt and Saudi is an illegal one concerning returning or giving 2 islands.
Right, in the Red Sea.
Yeah, so the president said, well, I respect the rule of law, but I think that the ultimate decision on this matter is for the parliament. And the court is not the parliament. Now, this issue cannot happen in Israel. I mean, politicians will be criticizing the Supreme Court, sometimes in an impolite way and violent way, but still they will respect that decision. And this is something not to be taken for granted.
And how is all this possible in the absence of a constitution? I mean, it makes much more sense in America, for example, to respect the rulings of the Supreme Court when you have that founding document to measure it against.
Well, there's a professional and unprofessional answer. The professional one, there is a constitutional heritage. Because Israel established its constitutional law step by step, one case after the other, etc., etc.
Like the United Kingdom?
Kind of.
Right.
But we have some basis, which is basic law, human rights, and human dignity and liberty. But the unprofessional answer would be the parliament is stuck. They enacted basic law, human dignity, and liberty. We have judicial review now. I know that there are serious politicians that want to get rid of that. But if they get rid of that, Israel looks bad.
Right.
So it's not the same thing as you're enacting something which you meant to have it the way it is or did not mean to have it the way it is, compared with other situations that you invalidated.
Right. So they acted too soon, now they regret it, and there's nothing they can do about it.
Of course. And the day before I spoke here about one situation of hypocrisy. Those politicians who criticize the Supreme Court of Israel for intervening in security issue, for instance, in Israel, in Hebrew, when they speak in Hebrew, they go abroad and they speak in English and they praise the Supreme Court for these cases to show the world, see, we protect human rights even in the age of terrorism. So this is kind of hypocrisy. You know, what is good abroad is not good at the national level.
Yeah.
And I think the Supreme Court is not part of the political game. It's doing its job. The Supreme Court does not create the situation. It basically responds to cases, and it's its own mandate to do that. And that's what the Supreme Court does. Successful, I have to say.
We mentioned earlier in passing the occupation of the Palestinian territories and the jurisdiction of the absence of jurisdiction of the Israeli legal system and the Supreme Court on it. How does that fit into the mold?
Well, you know, occupation is a bad thing, and with bad things you have bad consequences. That's beyond any doubt, I think. But I think the situation in Israel is not, the legal situation is not as worse as one could imagine. Not only compared with other occupations that took place in the world by England, by France, by Italy, and by the United States recently and back in history. But first of all, it was Meir Shamgar who served as the General Attorney. But even before that, when he served as General Attorney of the State of Israel, who decided that Palestinians in the occupied territory should have direct access to the High Court of Justice in Israel. This is a big issue in the United States with the Guantanamo and the Bori back in history, near history, right? So this is not a self-evident thing, which means that our constitutional values apply not only within the borders of the State of Israel, but even in the occupied territories. That's one important thing. The other important thing is that Palestinians are being dealt with through the military tribunals. And this is not a complete and comprehensive and enlightened system. However, it happened recently that it was decided that the general part of the criminal code of the State of Israel applies also to these military tribunals, which means that all the protected rights, including the legality principle, including the presumption of innocence and other, safeguards through the due process of law, are provided to these people. Is it the best? No. Is it the worst? No. It is somewhere in the middle. And with that, I hope we can improve. Yeah. Improve by ending the occupation to start with.
Yeah, that would be a huge step forward. What about you said that the Supreme Court is widely respected in Israel and abroad. What about its political influence? Is the Israeli Supreme Court more involved in directing policy than other Supreme Courts in the world?
I don't think so. I mean, simply by reviewing the history of Supreme Courts in the world, we can see that in America, for instance, the Brown versus Board of Education, the one that dealt with separate but equal, this was a serious move, and the decision was basically not respected in the beginning. And then we had the second Brown, where they issued a direct decree against the federal police officers to take the blacks and the whites and make sure that they sit together. This is not the issue. But, by the end of the day, the number of cases where the Supreme Court of Israel intervenes is way below the average of the number of cases that the Supreme Court does not intervene. Most of these cases are basically rejected. And the Supreme Court is doing its best through serious theories, legal theories, not to intervene and to respect the parliament and to respect the government and to give them chances to correct their mistakes and their wrongs. But once they decide not to do that, then the Supreme Court must, and it doesn't have even, I think, discretion on this issue, must intervene.
All right, Professor Mohammed Wattad, legal scholar at the University of California at Irvine and at Zefat Academic College here in Israel. Thank you very much for joining us today.
Thank you. And
also big thanks to Alex Benish, our sound engineer, and to the Van Leer Institute for the generous support. If you like this podcast, there are many more where it came from. Just go to www.tlv1.fm/podcasts and take your pick.